Ms. Graham.
Thank you. Do you remember before lunch I asked that decision 61 in the management policy log be put on the screen, and then I couldn't find the part I was looking for. I've had a chance to look at it again over the lunch break. Could we look at the policy file, please, PIRC 04154? And I'm actually looking at an email that was sent to PIRC, which sits behind, a copy of it sits behind decision 61. So actually this is on page 94 of the PDF. So this just sits behind where they were in, we've heard from Mr. McSpadden that sometimes certain documents would be simply slotted into the policy log and then summarised in the log without the need to copy a lot of text out. So this is, it was forwarded by Mr. Lewis, but if we can look at the actual email, it's from Mr. Anwar. It was sent to PIRC, primarily to Mr. Lewis, the flow, on the 28th of July 2015. So this is prior to your meeting with the family.
Yes.
And it's copied to Mr. McSpadden. And you'll see it says, "Dear Alistair," that's Alistair Lewis, the flow. And he says, "You may appreciate by now the family are highly dissatisfied at the manner in which the PIRC investigation has progressed to date." And this may be the correspondence from Mr. Anwar that you were mentioning earlier. But I'm interested in the second page of this email, and primarily Roman numeral number 5. "On a number of occasions, a meeting has been requested with Kate Frame, but the family and ourselves have not had the courtesy of a response to this request following her return from leave. If it is the case that Miss Frame is unwilling to meet us in the Bio family, then please advise." It would appear at this stage that Mr. Anwar is writing to say that on a number of occasions a meeting's been requested, but there had been no reply. Are you aware of any failure to communicate with the family in relation to a number of requests for a meeting with yourself?
No. When the request was made, or that I was aware of it, the flows were asked to seek dates from Mr. Anwar.
So when you had the meeting with the family, did you know that there had been a number of occasions where a meeting was requested that had just not simply been responded to?
No.
So you weren't armed with that information before you went in?
No, I wasn't.
Right. If you had known that a number of meetings had been requested but no reply received from the family, when you had your meeting on the 3rd of September, would you have addressed that with the family specifically?
Yes, I would have apologised if there had been that pattern shown, yes.
Thank you. Can I now move on and ask you some questions in relation to Mrs. Scullion, who was the head of investigations?
Yes.
And I think in your own statement, you explained that on the 3rd of May, although you weren't in the office that day, you had a call from Mrs. Scullion.
Yes.
This was after you'd heard mention of the incident in Kirkcaldy on the radio.
Yes.
And she had contacted you and updated you. I think there'd been some communication with Mr. Harrower, who was the lead investigator, and a decision was taken that you should be informed that day.
Right.
Because of the nature of the incident. And if we could look at your statement, please, and look at, let's start with paragraph 162. And you're describing the conversation you had over the telephone with Mrs. Scullion and the information that was being shared with you by Mrs. Scullion.
Yes.
The man had been seen chasing after cars with a knife. Police had been dispatched. Police Scotland had considered that it might be a terrorist incident. Against the backdrop of the information that she provided, I didn't understand why it had been considered to be a terrorist incident and asked why. She said it was because the man was what she described as, and this is in quotation marks, a coloured gentleman. And I asked her what she meant by that, and whether there was anything else to point to it being a terrorist incident. As I still found it quite difficult to understand what would cause the police officers to think that the incident was terror-related. She said that his actions in chasing after and striking at cars with the knife may have contributed to that belief, and she referenced an attack in England. Do you remember the attack in England that was referenced?
Yes, it was Lee Rigby.
Right. So there seems to have been a connection being made between Mr. Bio being a black man and this being a possible terrorist incident.
Yes, it seems so.
And you were asking why, what other information was available that would indicate that.
Yes.
And the response was that he was chasing out cars, and there was a reference to Lee Rigby.
Yes.
So the use of the phrase there, a coloured gentleman, is
Yes.
in quotation marks. Can you tell us what your reaction was when you say Mrs. Scullion, the head of investigations, used that language?
I was surprised. I was, I suppose, even more surprised in relation to the reference to it being a terrorist incident.
You were surprised at the connection being made there with the terrorist incident?
Well, yes, I was surprised that this was being referred to as a terrorist incident.
And we've heard that Mrs. Scullion was your head of investigations.
Yes.
Was it of any particular concern that the head of investigations was using the language a coloured gentleman?
It was of concern.
Can you explain what the concern was?
Well, the concern was the terminology being used.
And why was that of a concern to you?
Well, it certainly was making the link to the potential terrorist incident.
We've also heard evidence that people may find the use of the word coloured to be potentially to be offensive.
Yes.
Was that something you were aware of at that time?
Yes.
So what did you do when Mrs. Scullion used that word?
I did nothing at the time
Why was that?
because I was more interested in the circumstances that were being described to me.
Did you subsequently do something after the telephone conversation in relation to Mrs. Scullion's use of the word coloured?
Yes, I did later on, not that week because obviously I was out of the office, but later on.
Can you remember when you dealt with the matter?
No, I recall it was in the Hamilton House.
And is that the home of the
Investigations team. Yeah.
And after how long after you returned to the office after the break was it before you spoke to Mrs. Scullion?
Oh, some weeks anyway later.
And you say in your statement you did speak to her about her use of that word.
Yes.
And can you tell us what you said to Mrs. Scullion on that occasion?
There was some general discussion in the office, and I had said to her, did she appreciate that the terminology, the coloured gentleman, was not a suitable term.
What was her reaction to you raising that matter?
She accepted that.
She accepted. And when you say she accepted it, did you make it clear to her that it was her use of that phrase that you were referring to?
No, I probably said it in a more general term.
Right. So did you make it clear that it was a reference to her use of the language during that call on the 3rd of May 2015?
No.
So when you say she accepted it, is it possible she was accepting that as a general proposition rather than a reference to her use of the language?
Possibly.
In that you had heard her use those words and you had concerns, did you feel that you should take the matter forward to deal with the matter on a more formal basis with Mrs. Scullion?
No, I didn't. I thought having raised it, that was sufficient.
Did it cause you to have any concerns generally about your investigative team because the head of the investigations team had used that language?
No, I didn't. I didn't consider that, no.
Did you consider raising any issue with the team as a whole about the use of language and possible implications of using language that you did not consider suitable?
No, I didn't.
We've had, after you gave your statement, Mrs. Scullion provided a supplementary statement to the inquiry. Could we look at that for a moment? SPPI 00452. And if we look at paragraph 3, which is on page 8, she was asked about your discussion of the call she had on the 3rd of May, and she was referred to a number of paragraphs from your own statement. Those appear as italics in her response. And then if we get to paragraph 3 of her statement where she responds to it, it's on page 8. There we are. And it says, statement, I've been asked about a call Ms. Frame states that I made to her about lunchtime on the 3rd of May. While, as per my statement, I recall calling her around 10 a.m. to alert her that an incident had occurred, doing so to assist the on-call manager, Mr. Casey, who had been unable to locate Miss Frame's number. I do not recall the later call at around lunchtime that Miss Frame references, nor do I recall receiving further contact from either Mr. Casey or Mr. Harrower during the course of the morning that would have provided the information Miss Frame sets out in her statement. Mr. Casey's or Mr. Harrower's statements may provide clarity on the matter. I do recall having no contact with Police Scotland during the course of that day. And then if we can move down. As I cannot recollect the call Miss Frame refers to, I am unable to comment on its content as set out in her statement. I can only comment where my values have been questioned or where there are parts of Miss Frame's statement that I do not understand. And then paragraph 4. During the call with Miss Frame on the 3rd of May, did you use the phrase a coloured gentleman to describe Mr. Bio? And her response is, I have never in my personal or professional lives used such a pejorative term. Such language is completely alien to me. The only other term I would use in place of black is person of colour. Your statement, paragraph 5, includes that you indicated to Miss Frame that Mr. Bio was black. Can you recall the precise language that you used during this call to describe or discuss Mr. Bio's race? My recollection is that in the call I made to Miss Frame at 10 a.m. to alert her that an incident had occurred, I used the term black. I just wonder if you want to comment on what Miss Scullion has said about the comment.
I don't recall her using any term black throughout that call.
And where she has said, if we can look back again at paragraph 4, where she says, I have never in my personal or professional lives used such a pejorative term. Are you aware of any other occasion that you have been aware of that Miss Scullion used the phrase coloured gentleman or coloured?
No, I'm not aware of that.
Such language is completely alien to me. The only other term I would use in place of black is a person of colour. Do you have any comment about that or her use of that?
I haven't, I can't recall her using that phrase.
In relation to this conversation with Miss Scullion, is it possible that you were mistaken about Miss Scullion using the phrase coloured gentleman?
Instead of person of colour?
Instead of black or person of colour?
No, I don't recall black at all. Person of colour, maybe.
All right. Is there anything else you'd like to add to that? Now I've let you have a look at the statement from Miss Scullion.
Yes, it's a complete variance with my recollection of events. Certainly it was later than 10 o'clock as well. In the morning it was much later on.
Right.
And I recall that she had said that Mr. Harrower was actually either there in Kirkcaldy or on his way at the time.
We've heard evidence they didn't arrive till 1:30.
Yeah.
All right, thank you. I'd like to refer you back to an issue that we addressed yesterday afternoon. And towards the end of my questions yesterday afternoon, I have it for those behind me, it's line 172 it starts, at page 172, line 13. And I asked if you had any reflections on improvements that could perhaps have been made, things to support your investigators. And I asked you in particular about comparator evidence. Do you remember when we went through the guidelines yesterday afternoon?
Yes.
And one of the topics that they had within the guidelines was about comparator evidence. And I asked you about comparing how the person may have been treated compared to someone who was white, for example.
Yes.
And I asked you about that, and you said that was a consideration as part of the investigation. And I asked you if that was after the terms of reference had been expanded, which we've heard took place in September. The Crown extended them to cover race.
Yes.
And you said no, right from the beginning that was discussed. And I asked about what was discussed at the beginning, and you said it was, well, I certainly discussed it with a number of the investigation team. You said I discussed it with Mr. McSporran, Ms. Scullion, Mr. Mitchell, and a variety of other investigators. And I asked about the response you'd got when you discussed that issue, and you said they were receptive to it. And then I asked you to clarify whether it had been viewed as a positive and active line of investigation, or whether it was in the context of taking cognizance of issues as they emerged.
Yes.
And you said, I think it would be more under the second, the taking cognizance of. And we've not yet heard the conclusion of Mr. Mitchell's evidence, although we do hope to hear from him further. But in his inquiry statement, which we do have available now, and maybe we could look at this, it's SBPI 00423. And I'm interested in paragraph 433. That's it. So this is Mr. Mitchell's statement. I have been asked if, when investigating issues of race, PIRC considered attempting to identify comparator evidence that might have permitted PIRC to compare how Mr. Bio was treated against how other individuals, who were not black, were treated in similar circumstances. And he says, I don't believe so. I'm not quite sure how you could do that. I feel that it would have been necessary to identify incidents which were identical in all aspects of the events leading to and including the interaction between the police and Mr. Bio to draw a meaningful comparison. So in relation to the issue of using a comparator in the investigation, he said he doesn't believe that, I don't believe so, I don't believe that was attempted as part of the investigation. So we've also considered the evidence of John McSporran and his statement, and there's no reference to comparator evidence having been part of the investigation. And similarly, no reference to any discussions of this sort with Irene Scullion in relation to her inquiry statement. And I just wonder if you could perhaps give an explanation why, although you have recollected discussing comparator evidence with investigators, that Mr. McSporran, Mr. Mitchell and Mrs. Scullion don't remember or don't mention any evidence of this sort being...
My recollection is that the discussion was around, was there any evidence to show?
All right. That's what you were asking?
Yes, and also there was a conversation with Mr. Mitchell where he too was saying that that would be basically Could you show that now? Whether they went on to investigate that, I can't say definitively, but that question was posed to all of those members of the team.
Right. So Mr. Mitchell certainly seems to say here
That it wasn't possible.
was it considered attempting to identify a comparator?
Mhm.
And he says, I don't believe so. So it would appear that they did not attempt to identify a comparator or have that as part.
Yes, I could accept that.
You could accept
Yes.
that. But is your clear recollection that you did raise the question
It was raised, yes.
by you? Right. Thank you. Can I move on to ask you some final questions about Article 14? We have spoken about issues to do with Article 2 and the 5 procedural obligations. And you'll no doubt also have been aware about obligations under Article 14 in relation to requiring all of the rights and freedoms set out in the Human Rights Act to be protected and applied without discrimination. And were you satisfied when you were Commissioner that your investigators were aware of their obligations under Article 14? We've looked at documents, but they all refer to Article 2,
Yes.
and I've asked them about that. Were you satisfied your investigators knew about obligations in relation to Article 14?
No, I couldn't say that they were.
You couldn't say. Do you accept that PIRC had an obligation under Article 2 to conduct an effective investigation, independent? I think you already did accepted that yesterday. And do you accept that that obligation in carrying out an independent, effective investigation should be discharged without discrimination in itself?
Yes.
And it may be the case that we will hear further submissions or evidence about this, that where there is a suspicion that racial attitudes induced a violent act, it is particularly important that the official investigation is pursued with vigour and impartiality, and having regard to reassert continuously society's condemnation of racism and ethnic hatred, and to maintain the confidence of minorities in the ability of the authorities to protect them from the threat of racist violence. Is there anything I've just said that you would disagree with?
No.
So there are these positive obligations on PIRC in terms of the articles under the
Yes.
Human Rights Convention. And if we later hear that when investigating violent incidents, and in particular deaths at the hand of the state, such as police officers, state authorities have the additional duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in the events. Do you disagree with anything I've said there?
No.
So do you accept that PIRC had a duty to take all reasonable steps to unmask any racist motive that may have been underlying the death of Mr. Bayo?
Yes.
And do you agree that failing to do so and treating racially induced violence and brutality on an equal footing with cases that have no racist overtones would be to turn a blind eye to the specific nature of acts that are particularly destructive of fundamental rights, such as racism? Do you
Yes.
agree with,
Yes.
accept that? And do you accept that PIRC would have had to do what is reasonable in the circumstances to collect and secure evidence, explore all practical means of discovering the truth, and deliver fully reasoned, impartial and objective decisions without omitting suspicious facts that may be indicative of a racially induced violence? Do you
Yes.
accept that?
Yes.
We've heard evidence that the interim report was sent to Crown in August of 2015. We've discussed that briefly ourselves. And I think I indicated to you that the PDF is 351 pages long. There are multiple references in the interim report to a black male, black coloured, and a black guy. There's references to statements that were given and references to Mr. Bayo being black.
Yes.
There are 2 references to the UK terror threat level and 5 to an increased terrorist risk, terrorist plot or terrorist situation. In the entire interim report, there is absolutely no mention of the words race, racism, racist, racial discrimination. And no part of the interim report at all covers race or discrimination of any kind, not even to address it and exclude it. It is not mentioned. Considering the obligations that you as Commissioner had under Article 2 and Article 14, looking back and taking what I've said about the interim report, do you feel satisfied that the obligations on PIRC under Article 2 and Article 14 were complied with by PIRC, having failed to make any mention of race whatsoever in the interim report?
I think the report that was produced was in compliance with the terms of reference given, potentially, rather than those articles.
So am I to take it from that that perhaps you're not satisfied that it complied with Article 2 and Article 14?
I would suggest that it did comply with Article 2.
Article 14?
Perhaps I'm less satisfied on that.
All right. So if PIRC had properly taken cognizance of race, or had truly considered whether Mr. Bayo was treated differently because he was black and not white,
Yes.
are you satisfied that the interim report could have complied with Articles 2 or 14? Or would you like to explain how his race could have been entirely left out of that report?
I consider that further work could have been undertaken.
And looking back now, if as Commissioner, if you were Commissioner today and that investigation was ongoing today, would you expect now that race would be specifically addressed in that report?
I'm satisfied it would.
You're satisfied it would, and is that what you would have endeavoured to do if you were doing an interim report today?
Yes, and had I known how long it would have sat with Crown Office, if I had realised that there was an additional 26 or 28 months available for any investigation to be undertaken, I think every aspect would have been fully explored.
Did you feel you could not explore race after the 3rd of May because of time restrictions?
No, I'm not saying that. I'm saying that there have been, most likely to have been almost a perfect report that had covered all aspects if an additional 2 and a bit years had been provided.
And so do you consider your final report to be a perfect report,
I think there are gaps that could have been addressed.
even with the final report?
Yes.
Could you give me a moment, please? Thank you very much. That concludes my questions.
Thank you. Are there any Rule 9 applications? Miss Mitchell and the Dean. Miss Frame, would you
Yes, sir.
withdraw to the witness room, please, for a moment? Miss Mitchell.
There are 3 issues. The first issue relates broadly to something that my learned friend ended up on, which was the PIRC report and the question of race. The witness in her evidence yesterday at line 154, lines 9 to 15, accepted that the use of terminology such as coloured or linking the fact he was black with terrorism were issues which related potentially to race. But in a conversation with Mr. Mitchell, she said a view was taken that these were misconduct matters. Now, this inquiry has, of course, the PIRC report before it, and it knows in PIRC report volume 3 at part 15, there isn't anything about race and language used, i.e. expressions such as coloured or boy, etc. And there is no linking, even potentially, of race and terrorism in the report to the Crown. So the question, first of all, is simply because it's a misconduct matter doesn't exclude it from a PIRC report, and ask the witness whether or not she would accept that. And then to ask the witness, given her evidence and about the potential in relation to race, why these matters weren't contained within the report. The second issue relates to taking of statements, and they relate to two documents which were disclosed yesterday. The first of these documents is COPFS 03679. This is a letter from Mr. Lewis to Mr. Farrell at Crown Office. Oh, sorry, no, that first document isn't. That's a letter. That's a different letter about the written documents. What is clear from this document is that there are handwritten documents in respect of police evidence. Those handwritten documents are then transcribed, and they haven't been transcribed correctly. And it flags up several issues with that. And that is a statement in relation to Ashley Wise, one of the most important eyewitnesses to events. I wonder if the document could be put up on screen.
I'm sorry, I didn't really understand that at all, Ms. Mitchell.
Yes, so I think I've got a copy of the document if that assists. If we could see, this is a letter from Les Brown to Mr. McGowan, and it's about the typed statements for Ashley Wise. Now, the Crown, unlike the inquiry, has a copy of a handwritten version. And a task was completed where the handwritten version was compared with the version that was typed up. And even after it was spotted that a paragraph had been left out and assurances given that things were now well, as we can see as we scroll down, they are not. If we could scroll down, Mr. Alistair MacLeod writes to Les Brown, and if we can continue down, the paragraph which is left out is identified there. If we continue down further, it says, I have checked the whole statement, and worryingly there are a number of differences. The vast majority are typos, but there are a couple of omissions, which, though perhaps not material, are very concerning. I think we can be pretty sure PIRC have not proofread the statements once they have been typed up. I don't think we can rely on PIRC's letter of 26 October to say that they have checked all the statements and they are in order, given they have not even picked up on the mistakes highlighted in the statements when we have highlighted them to them. And what they asked to do is for copies of the manuscript statements to compare against the type copy and ask PIRC to do it. If we can just scroll down, we might see some of the differences involved. Some of them aren't major, but some of them are. For example, I draw the inquiry's attention to paragraph 4, line 3. The phrase "the lights were on" is not in the manuscript statement, but it turns up in the typed statement twice. And as we go on, there are just various differences. What I would like to ask Kate Frame about this was she aware of these problems, of the differences between typed up statements and handwritten statements? Did she instruct Mr. McSporran and Mr. Mitchell to review them? Because as we'll come on to see in the next document, it appears, and this is another document disclosed today, it appears that the Crown don't think that that job was done when they were given an insurance it had been. So that's the first document I would like to put to the witness, to let her see the difficulties. I would also like to ask about typed up statements. Are typed up statements to be retained? Where are they to be retained? If so, and can PIRC supply them if we don't have them? And then the next document is COPFS 02126A. If we can bring that up, please. As we see, this is from Alistair MacLeod to Justin Farrell, both of CAAPD. This is to highlight the work done by Crown Office in relation to investigating the death of Sheikha Bayo. The inquiry heard earlier on, just as Ms. Frame ended her evidence, she expressed the view that the Crown Office had taken some time in order to complete the inquiries after the document had been sent to them. If I can ask you to scroll down, if we go from background to the actual inquiries, there's a heading further down. I'm sorry, I don't have a page number for that, but if we keep going down. If we keep going down to the next heading. Crown investigation. In this part of this document, there are 6 issues that the Crown say that hadn't been carried out by PIRC, which were important to the investigation. I can take the inquiry to each of them. The inquiry might want to read this paper apart, but they are whether or not a comparator has been done with the information given by police officers to the information on the airwaves, and that doesn't appear to have been done by PIRC. Assurances given by PIRC that statements were now correct, which contained errors, was wrong. That the PIRC timeline that they identified contained inaccuracies and had to be redone.
Sorry, Ms. Mitchell, I'm not seeing this on the
Oh yes,
screen.
sorry, if we scroll down, I was just going to enumerate them, my Lord, so my Lord could read this, but if we scroll down here, statements, if we stop there, PIRC submitted almost 400 witness statements to the Crown, which were reviewed by the precognosers. And they identify that what happened was that they did cross-references. All the statements obtained from the material officers were also examined and compared to transcripts of airwave messages. This was to establish if there had been any deliberate attempt to mislead PIRC investigators about the incident about the incident at a certain time, e.g. whilst en route to Heathfield Road, perhaps with a view to justifying the level of force later used. An example where an officer might have appeared to be misleading PIRC was found within PC Walker's statement, and then it goes to identify that PC Walker said he was made aware by an airwaves message that the weapon had been described as a sword and the male appeared to be under the influence of a substance and attacking passing cars. But then, of course, what happened was a check was done of the airways to see whether or not that had been the case, and it wasn't. The paragraph continues, PIRC had not compared the material officers' statements with the airwave transcripts, and it was one of the necessary steps taken by the team to establish whether or not any of the material officers had attempted to pervert the course of justice. If we continue on down, accuracy of statements. During the precognition process, an issue was identified in relation to the accuracy of the statements submitted by PIRC. This came to light during the precognition of Ashley Wise. At page 60, volume 1 of the PIRC report, Wise was attributed as stating the deceased was lying on his back and that it looked like one of the police officers was using a baton on the deceased's upper chest towards his throat to hold him down. Wise provided PIRC with 2 statements, neither of which contained the above information. Inquiries with PIRC confirmed the original version and Clue 2 versions both contained the reference, but the paragraph had been admitted in error when the statement had been copied as it fell between 2 pages. On 24th October 2016, PIRC were asked to provide an assurance that all statements submitted to the Crown had been checked, to see that there are no similar omissions. On 26 October, Mr McSporran at PIRC confirmed all statements had been checked and were in order. At the beginning of 2017, there was further concern PIRC had not proofread the statements, despite Mr McSporran's earlier assurances. This followed comparisons of Wise manuscript statement and type statement, which revealed a number of typos and inaccuracies between the two. They see that there is further work that had to be done, and it doesn't appear that PIRC had done the work that they said they had. If we go down to the paragraph starting on 28th of April, on 28th April, the Commissioner advised the Crown by letter that a manual check of all the remaining statements had been completed, with each statement having been proofread and compared against the original handwritten version for accuracy. It is now clear the statement checking exercise had not been completed at the time of the Commissioner's letter, and it appears that that wasn't done until a later date, as the paragraph goes on. The initial failure to provide accurate statements caused significant extra work to be carried out by the precognosers. And as we can see, the amended statements required to be sent to all the expert witnesses. So it's to ask her about those particular matters. If we scroll down past the rib fracture to CCTV and timeline, we see here the CCTV and timeline at the bottom paragraph of that. It was analysed alongside a timeline produced by PIRC, which was found to contain inaccuracies. Although the footage is of poor quality, by contrasting the accounts of material witness, airwave messages and calls to Police Scotland, the precognosers were able to produce a detailed timeline of events for Crown Counsel. The timeline allowed the precognoser to pinpoint with confidence important markers in the incident, such as the arrival times of police vehicles, the duration of the restraint process, and the moment officers realised the deceased was in medical difficulty. Again, it was put to her if she knew that hadn't been done, whether or not that should have been done. And then if we go on to the precognition, we see a question as to, in the second paragraph, consideration was given to whether the Crown could simply rely on the statements obtained by PIRC, but this was not considered appropriate given the nature of the decision Crown Counsel was being asked to make. And if it was, again, to ask her if she knew that Crown Counsel and the Crown were not simply going to rely on the statements that were given to them by PIRC. Finally, if we scroll down slightly further, we will see that the statements, there's complaints about statements taken by Sean Mullen, in respect of Sean Mullen and Danny Robertson. And it says, although PIRC made reference in their report to Sean Mullen and his passenger Danny Robertson, it is respectfully submitted they did not fully recognise their significance. Both PIRC statements were relatively short and did not reflect the time they were at the locus. And I'll not go into that in detail, but it's just another example of the difficulties that the Crown had in respect of these statements. And what I want to put to her is whether or not she was made aware by the Crown of these difficulties with the PIRC investigation, and if so, what did she do about it? And the final matter that I would like to ask this witness about is in relation to another document disclosed, that was disclosed today, and that's SPF 00172. This is a letter dated 17th May 2017. It's from Callum Steele on behalf of the Federation to Ms Kate Frame. And if we scroll down to page 3 of that document, just the very top paragraph, if we just stop there, that's fine. These are bullet points which are being set out by Mr Steele. He states, PIRC declined an invitation to speak to an investigator appointed by the officer's legal representative in order that relevant information, including that of numerous witnesses the PIRC investigation did not identify, could be shared. And what the questions around exploring that was, how did the Scottish Police Federation know what statements had been taken and hadn't been taken? And also what, if anything, was done in respect of following up this matter, where there's an allegation that statements hadn't been taken of relevant people. And secondly, it says, PIRC appear to have no interest in investigating the full, as they describe it, capitals, circumstances of events leading up to the death of Mr Bio, and in particular the actions of and information known by Colette Bell and Zaid Said. And again, the question would be, did you have any understanding, or did you know how SPF would have known what the PIRC were doing in relation to these witnesses? Those are my questions.
Thank you. If you go back to your seat, Robert.
My Lord, two issues from me. The first is that yesterday, in the course of questioning, the witness was asked to comment on, in particular, this is page 98, lines 13 to 20, what her views were in relation to use of force against a particular hypothesis, being that the officers, including Craig Walker, got out the vehicle and went straight to using CS and Pava spray, apparently without warnings. It will be my submission that that is not, or at least not necessarily, an accurate reflection of what happened, and I would like to put the alternative hypothesis to this witness for the same comment that she was invited to make yesterday. And the second issue, my Lord, relates to the question of the Federation statements to the media and the PIRC response to that. The witness has today been critical of the Federation with regard to the making of the statements over and above that which was said in the witness statement, and I would like to clarify that with her, in particular with reference to PIRC's own response to what had been said, and to take up with her the suggestion that stereotypes were resorted to in the Federation statement. Thank you, sir.
Consider these submissions. In relation to the Dean's 2 lines of questioning, I shall allow each of these. In relation to Ms Mitchell's first issue in relation to the PIRC report and race, I shall allow that line of questioning. In relation to her third issue, that's in relation to a letter from Callum Steele to Kate Frame, I consider that that touches upon a matter which is the subject of a separate application, and I shall refuse permission for questioning on it at this stage. The matter that Miss Mitchell raises in her second issue in relation to a number of matters arising from documents from the Crown which have really only been just disclosed, excuse me, I consider that this raises a matter which does require to be explored. Counsel to the inquiry had not had an opportunity of studying these documents. Miss Frame is travelling abroad tomorrow morning. What I propose to do then in relation to that is not to permit questioning of Miss Frame on that today, but that counsel to the inquiry should explore these issues with Mr Mitchell, with the possibility of a further Rule 9 application in relation to that with Mr Mitchell. These issues, of course, will be canvassed with the Crown in the next hearing, and they can be revisited with Miss Frame in one way or another in due course. So what we shall have this afternoon is Miss Mitchell on her first issue and the Dean on both his issues. So can we have the witness back, please? Ms Frame, Ms Mitchell KC, who represents the families of Shekubayo, has some questions for you.
Thank you.
Yesterday you gave evidence to the inquiry in relation to references to language about the term coloured and about linking the fact that Mr Bayo was black with terrorism. And you confirmed to this inquiry that you thought that those were issues emerging which related potentially to race. Do you recall saying that?
Yes.
And you said on raising them, and you raised them, we understand, with Mr Mitchell, a view was taken that these were misconduct matters. Was the view taken by both you and Mr Mitchell that it was better placed as misconduct matters?
I had reservations about that, but respected Mr Mitchell's view from the police perspective, and the view, our final view, both views, would be that it was to be submitted to Crown Office, and if they took the view that there should be further exploration, it could be referred back. But that was in recognition also of the fact that the statements had already been with Crown Office for, I think, a year.
Can you tell the inquiry what your reservations were?
My original reservations were that they should have been explored.
And why simply did you defer to Mr Mitchell on that point?
I respected his insight into the misconduct, his view of the misconduct and what that amounted to.
Well, you were the commissioner and you'd been asked by the Crown to examine if race was a factor in the death of Mr. Bio.
Yes.
So that was an issue that you were to consider.
Yes.
And you have considerable experience yourself in relation to evidence as a lawyer and in relation to whether or not you could assess if that might be a factor. Did you not consider thinking of your own views having any degree of priority in something like that, given the terms that you'd been asked to investigate?
Yeah. I only realised that on exploring the final report, and at that stage raised it.
What do you mean in exploring the final report?
When
Because
it
that was a
was-
matter I was about to come on to.
Right, okay. When the final report was submitted, having been through the quality assurance process, it was forwarded to me, and at that point I went back to Mr. Mitchell and queried whether there had been any exploration of this.
So can I just check, that's at a time before the final report was sent to Crown Office?
It was literally as the final report had been prepared.
And knowing what you did about the fact that the terminology had been used which could be considered race-related, that the fact that he was a man being linked with terrorism, why didn't you say, stop, why isn't this in the report? Why isn't this in the report about race?
Well, that was my query.
And how was that followed up?
Well, we discussed it, and his view was that it was to be treated as misconduct.
Why isn't it both? Why could you not include it in a report where you've been asked to examine if race was a factor, and also used as something to flag up in the PIRC report under the issue of race?
That is something that could potentially have been done, yes.
Thinking about it now, is that something that should have been done?
I agree that there should have been further exploration of that.
Because what we know from the PIRC report, we've received the 3 parts of it, and at part 15 there is nothing about the issue of possible racist language, and there is nothing about exploring the issue of linking race and terrorism.
The question of terrorism was, oh yeah, okay, it was discounted by, well, I was told by Mrs. Scullion that, having told me that there was this terrorist thought, that within minutes she said, but it isn't, or words to that effect. So it seemed to have disappeared from being part of the equation. But I take your point in relation to the connection being made.
Yes, because it's not a matter of whether or not it was explored that there was an issue of terrorism.
Yes,
There was,
I get that.
from the very outset, no consideration that this was a terrorist issue in any real sense.
Yes.
The question is that when you've been asked to examine as Commissioner if race was a factor in the death of Mr. Bio, and you have evidence that witnesses are linking the colour of someone's skin with terrorism, why you didn't see this must be explored and it must be flagged up in a report to Crown Office under the heading of race.
Well, I had expected that to be done after the receipt of the witness statements.
And why didn't you then, before the report went to Crown Office, say we must stop and we must put those in because they're important things?
Because at that time there was the expectation that it was being delivered to Crown Office. This had been held up. There was considerable pressure being placed to get that to Crown Office.
Well,
And that precisely, I think I said earlier today, had I thought that it would have been acceptable for there to be another 22 months tabbed on that would have been something that I would have certainly.
But surely, with respect, Ms. Frame, we shouldn't hear that speed sacrificed content.
I agree.
So do you accept that you should have taken the time to include those issues in relation to race in the PIRC report under the heading of race?
I think they should have been further explored.
And flagged up in the report?
Well, and in the report they had been flagged up because those statements had already been submitted to Crown Office.
Yes, but in the report itself dealing with the issue of race, they hadn't been flagged up.
That's right.
And I'm asking whether or not you now accept that they should have been.
I think they should have been, yes.
No further questions.
Thank you. The Dean would come forward. Ms. Frame, the Dean of Faculty represents the Scottish Police Federation and certain of the attending officers. He has a line of question for you.
Thank you.
Afternoon, Ms. Frame.
Good afternoon.
There are two issues I want to explore with you, please. The first relates to questions that you were asked yesterday about the use of force by the attending officers. And you may recall that the hypothesis was put to you that the first two officers had gone straight to using CS and PAVA apparently without warnings. Do you remember that?
Yes, I do.
And you were asked for your view in relation to that. Now, you weren't an investigator in this matter, were you?
No, I wasn't.
You weren't immersed in the detail in the same way as your investigators such as S.I. Little were.
No.
Those investigators would have had to look at all of the information available to them at any given point of time, is that right?
That's correct.
And in this, as in much in the law, context is everything.
Yes, I accept that.
Do you agree with me that there's a danger in asking you to comment on matters in summary detail now when the PIRC investigators, very senior investigators, had the whole picture before them?
Yes, and I consider that at the time.
Now, on this scenario of the officers getting out of the vehicle and going straight to the use of incapacitant sprays, if his lordship were to find that in fact the position was rather different, where we've got reports of Mr. Bio attacking vehicles with a knife, the possibility of a knife remaining on his person but concealed, training to the officers that they must assume he's still in possession of a knife until it's demonstrated otherwise, officers giving lawful commands to stop and get on the ground, those commands being ignored and Mr. Bio continuing to advance on the officers. If that's what is found, all of that would be highly relevant to the investigators in their consideration of matters, wouldn't it?
Yes, absolutely.
And as discussed with Ms. Graham in questioning, you yourself drew a distinction between the initial use of incapacitant sprays and the subsequent restraint of Mr. Bio. Those are two separate matters, aren't they?
Yes.
And the investigators would have wanted to know the full picture as to why the restraint was affected.
Yes.
And highly relevant in that consideration would have been information to the effect that Mr. Bio had punched a female officer to the ground.
Yes.
Also relevant would have been information to the effect that thereafter he had stamped on her.
Yes.
And all of that is material you would expect the investigators to take into account.
Yes, and I understand they did.
Yes. Well, indeed. These are, in your view, dedicated professional investigators.
Yes, they are seasoned investigators.
And there's nothing to suggest to you that they didn't take such matters into account. Indeed, as you've just told us, as you understand it, they did.
Yes.
Okay, thank you. The second question relates to your comments on the Federation statements, the media statements.
Yes.
Yeah? Again, do you agree with me that context is important?
Yes.
The Federation is there to represent police officers, is that right?
I recognise that.
Now, you've not been a police officer, but you'll be familiar with the responsibilities of the Police Federation.
Yes.
And thinking back to when this was happening in 2015, there was a somewhat febrile environment in the media about all of this, was there not?
It was exceptionally highly charged.
Yeah. The Federation wasn't just coming out with statements off its own bat, it was reacting, was it not?
I can't remember the sequence.
Well, if His Lordship finds that statements were being made on behalf of the family, for example, through their solicitor, for understandable reasons, but if he finds that that was happening, does that accord with your recollection that the family were being critical of the police and demanding that the police be held to account?
I recall there were critical comments. I can't tell you in what sequence they appeared.
Does it also accord with your recollection that the family were calling for the officers to be suspended pending the investigation?
I recall that.
And it may be, His Lordship may find that these statements were made in response to those demands, and if he does find that, that's the sort of thing you would expect the Federation to be doing, isn't it? Defending their officers.
I would expect them to be representing their officers. I would not be expecting them to be promoting evidential matters.
So you would be critical of any public statement being made in this context?
I'd be critical of salient evidence being shared publicly, particularly when the officers themselves hadn't provided statements to the investigating body.
Well, you see, the difficulty I have with that, Ms. Frame, is that PIRC responded to what the Federation was saying.
Yes, and it didn't provide anything of an evidential nature.
Well, it contradicted what the Federation was saying.
It contradicted that to the extent that it said that attempts had been made.
Well, if your criticism is that the Federation said X, why are you not equally or why are you not equally critical of the fact that PIRC went to the media and said it's not X, it's Y?
I think I explained that this morning, that the Federation had come out with that version. The family were actually questioning the fact that those statements had been previously requested, and the PIRC was actually caught in the middle of what was, in my view, an inaccurate statement by the Federation.
There's a distinction, isn't there, between the Federation and the PIRC? Federation is there as a representative body. It's got no obligation to be independent. Is that right?
Well, I don't, yes, I would presume so. I don't know that.
Yeah. Whereas the PIRC, you, as we've understood, the commissioner, not the commission.
Yeah.
The independent review commissioner, you've got an obligation to be independent.
And also to secure public confidence.
Yeah. But in that context, is it not rather odd to find that you're critical of a representative body of officers who've been attacked in the media, defending them in the media, and yet you're not prepared to entertain any criticism of the independent body that then goes to the same media with public comments?
Well, if the Federation were providing an accurate reflection of what the PIRC's action was, that would have been fine.
Yeah. Okay. And if His Lordship were to find that what was being said by the Federation was understood in good faith by them to be accurate, then you would retract that criticism on the basis of what you've just said.
No, I think the criticism was made. It would have been appropriate for the Federation to retract it publicly.
Well, if the Federation, if those responsible for these statements genuinely believed what they were saying was accurate, then on the basis of what you've just said to us, you wouldn't have a criticism. Your concern is they weren't true. But if they were understood to be true, you wouldn't have the same criticism.
Well, the difficulty with them not being true was, A, they were undermining public confidence, they were an inaccurate reflection to the family, and the PIRC was in a very awkward position because those two conflicting positions, and it would have been perhaps slightly more appropriate if the Federation had expressly approached PIRC with an accurate understanding, or in the case that it would appear to be an inaccurate understanding that could have been corrected.
But that answer again has as its core tenet your belief that what was being said was untrue. So I'm asking you to look at it in a different way. If it was either true or genuinely and in good faith believed to be true, then your criticism doesn't apply. Is that not fair?
No, my criticism would still stand in relation to the sharing of any information publicly.
And the responding to that by PIRC is absolutely fine, is it?
No, PIRC were not responding to the evidence. They were responding to the comment about not having been approached and giving that implication.
Okay, well, we'll perhaps leave that there. Just a final point then, please. You talked about, or you were critical about stereotyping in the Federation statement. On the basis it indicates that a petite male was attacked by a large male.
Yes.
Have you met PC Short?
No, I haven't.
She's 5'2". You agree with me that's petite?
It is small.
Mr. Bio was much taller and much heavier, yes? To your understanding?
Yes, from my recollection of the report, yeah.
And on any view of the evidence, Mr. Bio ran at PC Short, chased her, struck her to the back of the head, and knocked her to the ground. Is that consistent with your understanding?
Yes.
Now, you were critical of saying that was stereotyping the black man as the aggressor. If he did act in that manner, run at PC Short, knock her to the ground, then he was the aggressor, was he not?
Yes.
That's not stereotyping.
I would
Agree?
Yes, I'd agree with that.
Yeah, okay. Thank you, Ms. Frame. Vice Lord.
Ms. Frame, thank you very much for coming to give evidence to the inquiry. I'm very grateful for the time that you've given.
Thank you.
Inquiry is about to adjourn and you'll then be free to go.
Thank you.
Inquiry will adjourn.